All right, looks like we got a decent group. I think we can start, Nathan.
All right. Well, on behalf of the MDTC appellate section and MDTC as a whole, I'd like to welcome everyone to this lunchtime webinar. How to win your appeal in the trial court, or at least how not to lose it. It's my pleasure to introduce our panelists, Judge Christopher Yates. Judge Yates has been on the Court of Appeals for the last year. Prior to that, he was a Kent County Circuit Judge for approximately 14 years. Judge Yates is also a former recipient of the MDTC Judicial Excellence Award, among many other honors. We are happy to have him here with us. We also have Tim Diemer, partner at Jacobs & Diemer, appellate specialist, and it's my pleasure to introduce Tim. He gave me my first shot in the appellate world in private practice, and I'm always grateful for that. We also have Samantha McLeod, associate at Jacobs & Diemer, an appellate practitioner, and she's going to be the moderator. So if you have any questions, please, send them in as you get them under the, is it under the chat function or the Q&A function? I'm not sure which one we're using, but get questions into Sam and we'll field those as we go. So Tim, take it away.
Thank you very much, Nathan. Thanks, MDTC. Thanks, Samantha. Thanks, Judge Yates. Every appellate lawyer has his or her own nightmare story of the perfect issue on appeal that is potentially dispositive, but unfortunately, it is unpreserved. And that's the kiss of death for even the best appellate issues. That's going to be the focus of our topic today, how to not lose your appeal in the trial court by not raising it. We have maybe 30 to 40 minutes of information to present. We want to leave as much time as possible for questions and answers. So feel free and please use that question and answer and chat function. Any questions you get, Samantha will take the questions in and field them at the appropriate time. I'll also offer some introductory remarks before getting into the meat of the program. We're all familiar with the general rule of issue preservation, that an issue must be raised in the trial court in order to preserve the issue for appeal. In addition to providing specific tips and specific examples of how best to preserve an issue, I wanted to start with maybe a basic understanding of why our system has issue preservation requirements. And if you're ever in doubt about how to preserve something or what to do, I think with these general principles in mind, you might have a better opportunity of figuring out what exactly the best course of action is. Although we're all civil practitioners here today, there's a quote from a criminal court of appeals opinion from 1997, People v. Mayfield, that I think best crystallizes why we have issue preservation rules. The quote is, "The purpose of the appellate preservation requirements is to induce litigants to do what they can in the trial court to prevent error and eliminate its prejudice, or to create a record of the error and its prejudice." I think we're all very familiar with that second aspect of issue preservation. The party must raise the issue, let the trial court decide it, and without a record of the trial court's decision-making and the arguments that were presented, there's nothing for the appellate court to review. That's generally how we understand issue preservation. But the first clause, I think, is an underrated aspect of it. Again, that's to prevent error and eliminate its prejudice. The Court of Appeals is an error-correcting court. If you don't raise an issue in the trial court, it is not the trial court's error. It then becomes your error. So if you're going to ask the Court of Appeals to bail you out of a jam, you're better off having taken every possible opportunity available to you to prevent that outcome from occurring in the first place. Again, there are a couple of different reasons for this rule, why we have self-help remedies available that must be implemented before you file your appeal. Fairness and efficiency are the two primary reasons. Again, if you don't raise an issue in the trial court, how can you point the finger at the trial court? It's the trial court screwed up when it's your own failure and your own fault for not raising it. Then also efficiency and fairness. Instead of going through a long, complicated 2 to 3 year trial court proceeding and not to raise anything and then to spring it on everybody for the first time in the Court of Appeals is really unfair. It's unfair to opposing counsel. It's unfair to the trial judge, your opposing client, sorry, your opposing party. If it's a jury trial, it's unfair to the jury to waste everybody's time when you could have done something to prevent this prejudicial error from occurring, and you don't do it to get to the Court of Appeals in the first place. So for these reasons, the first question, I know Nathan had the same experience I did working at the Court of Appeals as a research attorney. When we were asked to analyze an issue, analyze a case before submitting it to a panel of judges, for every single issue that the appellant raises, the first thing we did was address whether the issue was preserved or not. So if you file an appeal, you're going to have the research attorneys doing issue preservation check. Then you're going to have the judge's law clerks performing issue preservation check. And then you're going to have the judges performing issue preservation check. So if it's not preserved, you're going to get caught. You can't sneak an unpreserved issue past the panel. So do everything within your power, preserve the issue, get a decision from the trial judge before you move on to filing your appeal. So that's kind of the general outline of why we have issue preservation rules. Now we'll move into some more specific examples. And we are very fortunate to have Judge Yates, given his extensive background on the trial court and now on the Court of Appeals. So he's kind of got the dual perspective here of best practices in the trial court and then best practices in the appellate system. So we'll start with motion practice, how to preserve the record, both legal issues and the evidence and materials you want to rely on in your appeal. For cases that don't amicably resolve, the vast majority, between 90 and 95%, are decided on motion as opposed to jury trial or bench trial. So preserving issues for motion practice is probably the most important thing we hope you can take away from today. So I'd like to start with maybe a question posed to Judge Yates. If you could maybe share with us some practical tips on how to manage competing goals in the trial court of how to raise everything and how to supply all the information you might need, but at the same time, how to do it without irritating and aggravating the judge, wasting the judge's time in the trial court. And then maybe a follow-up question would be, now that you've been on the Court of Appeals for roughly a year, whether your perspective has changed now that you're on the Court of Appeals after having been a trial judge for so long.
Well, thanks, Tim. Let me, first of all, thank MDTC for asking me to do this. I'm always happy to talk with those of you who are practicing in the field. And I well recognize that it's a lot harder to do what you do than what I do, whether I was a trial court judge or a Court of Appeals judge. I haven't forgotten how hard it is to be a practicing lawyer. And if I ever do, I'm going to quit the bench, I promise. My perspective is this. My first 4 years as a trial court judge, I was a generalist. I had a family, criminal, and civil docket. And then my last 10 years, I was a business court judge, and so all I did was commercial litigation. What I found in commercial litigation was that everybody buried me in paper all the time. Motion and brief, response, reply, surreply, surreply, supplemental brief, and so on it went. So I never found in my last 10 years that somebody had failed to make a record on a motion. It was quite the opposite when I was on the general docket. And it was not uncommon for people to submit very bare bones motions and just expect me to figure it out on the fly. As between the two, I guess I'd prefer that you not bury me completely or bury a trial judge completely, but you've got to say enough to make sure that the argument is well presented. Remember, the first goal is to try to win the case in the trial court. And so there's no doubt that you always have to be looking over your shoulder and making sure that you're preserving issues for appeal. But the best reason for making a good record in the trial court is to win the case there. In a perfect world, we wouldn't even need appellate courts because trial judges would get it right. And the more you help the trial judge get it right, the better off you and your client are going to be. So the best piece of advice I can give you is include everything that you think anybody carefully reviewing the case would want to have. Having said that, and having received briefs that sometimes came in bankers' boxes in the business docket, I would say that at least in complex commercial litigation, there's a tendency to err on the side of over-inclusion. And it's hard for me to draw a bright line on this, but for example, if you're going to provide a deposition, I want the whole deposition. If, on the other hand, you're going to attach a whole bunch of documents that are relevant to a contract dispute, please do your best to weed out the duplicates that come along with that. I don't need to see pleadings attached, and anything that makes your submission a little shorter is appreciated, especially when you give me a roadmap or an index or something like that, so I can easily make it through your attachments.
Maybe one more follow-up question. Has it changed, or has your the aggravation level softened with e-filing, paper filing? You know, if it's, you got 10 deposition transcripts and contract documents, I mean, it could be this thick.
Yep.
And you can really irritate the trial judge, the clerk's office, everybody else. With e-filing, has that softened at all because it's now just one big PDF?
We were running e-filing for 10 years in the business docket. We were allowed to pilot it, and in the pilot period, we set up a really sophisticated e-filing system that probably seems a little clunky today, but back in the day was really quite an innovation. And I did find that it made things a lot easier. I mean, I'll confess that in a case where there's a particularly significant document, an insurance policy, or a contract, or an operating agreement for a limited liability company, I'm going to print that document out so I can work with it, highlight it, mess it up, put tabs on it, do all the things I want to do. But for most documents, yes, it's much easier to just have them in electronic format. In the Court of Appeals, you probably don't, well, some of you probably know this, but we get an electronic version of the record in every case, and I can rip right through the electronic version of the record. It's a lot easier than pawing around in a file filled with paper documents. So yes, it is easier these days with electronic filing, no doubt about it.
This gets my own, maybe on my own personal question here. With a few of the counties still in paper filing, Sand Lac, Livingston,
Mhm.
does the Court of Appeals get electronic record, everything scanned in and sent up, or do you still get the old paper, the box?
Yes, some poor person actually has to scan everything in. We can call for the record and then we get all the paper. And I've done that on occasion. Sometimes it helps me to just dig around and see what's going on, but it's pretty rare that I actually go to the paper file anymore.
Okay. All right. Thanks for those comments and
Sure.
insights. And I don't see any questions have popped up yet. So maybe move on to our next topic. Still within motion practice is going to be motions for summary disposition. Again, I'll quote another Court of Appeals case. This one's from 2014. This civil case, and quote, in general, an issue is preserved if it was raised in and addressed and decided by the trial court. So we all know, raise the issue, present it to the trial court, but sometimes you're going to raise an issue and it might not be addressed. You know, for example, on a major case, you might file a motion for summary disposition with 5 or 6 different issues, and the trial judge might find one dispositive. And maybe, Judge, if you could explain and address, you know, the right result, wrong reason doctrine, and maybe when that would be an appropriate position to take on appeal, and when maybe you're stuck with the one issue that the trial judge actually did rule on.
Yep. Let me start with something very basic and then talk about something a little bit more nuanced. The most basic thing about motion practice, particularly summary disposition motions, is to clearly and correctly identify the sub rule on which you're relying. Nothing drives me crazier more than seeing something requesting relief under, you know, C4, C6, C7, C8, C9, and C10. The other thing about that is that you have to be really careful when you're differentiating between a motion under MCR 2.116 C8 and one under 2.116 C10. What I find a lot of times is that people submit these motions that I call tweeners, where it's kind of a C8 because it's early in the case, but there are attachments because, boy, Judge, if you could just look at these 3 documents, you'd be able to figure out what's going on. And the problem with that is the rules don't contemplate something between C8 and C10. And I know it's frustrating because a lot of times on the defense side, you think you can knock a case out fairly early on, but you can't do it just by strictly relying upon the contents of the complaint. And so you really do want to tell the judge, look, we can save ourselves a lot of time here if you'll just look at a couple documents and match those up with the complaint, and then you'll see that there's really nothing to this case. I wasn't absolutely opposed to early C10 motions, but please understand that when you're a trial court judge, you're judging defensively. And by that, I mean, you're trying to make sure you don't do something reversible. And one of the great dangers as a trial court judge is to take on C10 way too early. I know that lots of people want to get rid of cases right out of the box, but we're not an Iqbal Twombly jurisdiction when it comes to pleading. C8 means what C8 says, and they've said it over and over again. It's a very generous standard. And then C10 largely should be put off until the close of discovery. So one of the things I would suggest when you're trying to figure out how best to package a motion is to make sure if there are page limitations, you're doing your level best to stay within the page limitations. On the Court of Appeals, for example, you can submit a 50-page brief, and I can't imagine any case ever where you need more than 50 pages. I mean, but some people treat it like bull riding. I mean, you got to make it to the bell. So you're given 50 pages, you're right for 50 pages. I did a huge amount of appellate work as a lawyer, and I tried to make every brief as short as I could. They're far more persuasive when they're shorter. And I'd say the same thing about briefs in support of or in opposition to motions for summary disposition. There's nothing to be gained by submitting a 75-page brief, even if you can talk the court into taking it. It's just not productive. Now, as far as arguments that are raised and then do not become the basis for the trial court's decision, if you're the appellee on an appeal, you certainly have liberty to make other arguments that would be dispositive in the case. You don't have to exclusively rely on the reasoning of the trial court. But please understand that those of us on the Court of Appeals are far more likely to try to rest the decision on the accuracy or inaccuracy of the trial court's decision. And so if you want us to go off on 5 separate issues, you may think they're great issues, but we don't have the benefit of any real development of the trial court's views on those issues. And so I prefer not to stray too far from what the trial court decided, but in some cases, you're right, Tim. There is just a lay down winner, and for some reason, the trial court didn't choose to go with that particular argument. It chose another one, and I'm always open to listening. It's just what I see is that there's so many suggestions of arguments that are just here, there, and everywhere, and it's difficult for me to make heads or tails out of them, particularly when they're being briefed extensively in an appellee's brief. And so all the other side has to work with is a reply coming back.
Yeah, that's helpful. From my experience, if you're filing a dispositive motion, you might have what you think is one great issue, but to give the second, third arguments some airplay, just in case there might be a change in the law during the 18-month period from filing of an appeal to the conclusion of the appeal, and maybe issues 2 and 3 are still viable, but issue 1 is not. And no two people see things exactly the same, and I'm sometimes amazed. I'll raise 2 or 3 arguments. I think argument 3 is kind of weak, but maybe that's the one that the audience is receptive to. But if you don't raise them in the trial court, I don't know how much luck you're going to have with right result, wrong reason if you present it for the first time as an appellee.
Right, no doubt. You have to raise it in the trial court. You can't just come out of left field with an argument that nobody's seen until we get your appellee's brief. That's really unfair to the appellant. The other thing I'd say is that I hate to generalize, but I'm going to generalize a little bit here. In personal injury cases, my experience has been that there aren't that many issues. And so usually the issue that's dispositive is readily identified by both sides, and we don't have to go very far astray. The cases that used to drive me nuts were particularly when you have an insurance company against an insurance company. And boy, each side's willing to give you 27 reasons why they win. I hated that. I mean, if you win under the policy language, just tell me you win under the policy language and why. I don't need to know about some hoary concepts of, some ancient common law doctrine that I don't feel like chasing down.
Yeah, that's good to know. I mean, obviously, if insurance policy got hundreds of pages of documents, 100 pages of clauses and exclusions, exceptions to rely on that.
I get it. There's no coverage, but if there's coverage, this exclusion applies. But if this exclusion doesn't apply, then the next exclusion applies. I mean, I get that. I understand it, but it gets a little complicated.
And then a follow-up question on motion practice before we move to trial and post-trial procedure. one issue that I know from my experience is debated extensively with the clients, with the trial attorneys, with everybody, is knowing when to file an interlocutory appeal, when to wait for final judgment. And I'm curious, Judge Yates, if you have maybe some characteristics of cases that you think are ripe for interlocutory appeal, and which ones you're better off not shooting that bullet until after you have a true final order in the case.
Yeah, Tim, I'm glad you asked me that question because at the bench bar conference, when I was a baby judge on the Court of Appeals, the junior associate there, I was in a large discussion group on motion practice, and I hadn't sat on motions before, so I had nothing to offer. Now I've had the experience of spending a year on motion panels, and I have very strong feelings about a lot of it. For me, in the months where I'm on motions, and that's 6 out of every 12, I typically get about 15 motions every week to review. So you're talking about 60 motions in a month. Many of them are requests for interlocutory appeal. And I have pretty strong feelings, partly because I grew up in the federal system where the final judgment rule is pretty tough. And then second, because I was a trial judge for a long time, that we on the Court of Appeals shouldn't be poking our noses into cases very often. And particularly when the trial court seems to have it under control, the last thing the trial judge needs is to have the case disappear into the Court of Appeals for a year and a half. I had any number of cases in the commercial docket where I thought things were completely under control, and then somebody files an app for leave and they want me to wait until we get a decision, and I'd refuse to. And I hoped that people would trust me when I told them this is something I think I would be glad to see you get an app granted on. And then there are lots and lots where there's just no point to it at all. If you have a really novel issue that's completely dispositive of the case, you're likely to get an app granted in those circumstances. If you simply file a motion for summary disposition under C10 and you lose, particularly if the judge says there's a genuine issue of material fact and here's what it is, those are really poor candidates for app for leave. Do we sometimes grant them? Yes. Are we inconsistent from motion panel to motion panel up here? Yes, because different judges have different views. But my view is that of a former longtime trial court judge who really would prefer to have the Court of Appeals only weigh in at the end of the case or when something really is outcome determinative and you can save yourself a long trial by getting a decision before the trial takes place.
Excellent. That's an illuminating answer on interlocutory appeals. Motion practice, again, I don't see any questions have popped up, so I guess we can transition on. Sure. Now moving into trial proceedings. And again, I think this is going to be having your experience on the trial court is going to be a huge help. Again, my experience, most trial judges are gracious and accommodating to letting attorneys make their record. Most judges can appreciate you're in private practice. You might want to file an appeal. I'll give you the time and space to make your record. I might rule against you, but have it at it. And then, so at that same time, we don't want to, those of us in private practice don't want to abuse that privilege and go on and on and on and on and drive the judge crazy and take a accommodating judge into an irritated judge. So maybe if you can offer some, again, views from your trial court experience, not for appeals experience on, tips and best practices for how to avail yourself of the opportunity to make a record without pushing things too far.
Well, first of all, let me say that the operating philosophy of trial court judge is that you never want to impinge upon the time or patience of the jurors. And so I always did my best to try to keep trials running smoothly when they were taking place. I could avoid bothering the jury in a couple of ways. First of all, I would always set a regular process for motions in limine to be filed before a trial. That doesn't mean that I liked getting 30 motions in limine, 5 of which effectively said, will you follow the rules of evidence? Yes, I'll follow the rules of evidence. But well-designed motions in limine that clean up several difficult issues before trial are very much appreciated because we can have a more comprehensive discussion without wasting the jury's time. The other thing that I did is that whenever I thought something complex had come up on the fly, instead of trying to do it at sidebar, which is unmanageable, even though we recorded sidebars, I would ask the jury to leave the courtroom. I'd take them out myself and then apologize that we were going to take a break, but we were going to be at it for a few minutes. And I tell them this is important. And I promise we'll get back to you as fast as we can. And then have a full-blown discussion on the record. Now, I don't know how most judges feel about that, because I'm only one former trial judge, and I know there are lots and lots of trial judges in the state who may have different views. But to my mind, appellate review is such an essential component of the legal system that it was incumbent upon me to always let people make a record for two reasons. First of all, I might be wrong. And if I'm wrong, I want you to be able to explain to me why I'm wrong, so I don't screw it up and force a second trial. In addition to that, it's just important to let the attorneys have their say when they think that they have a strong issue and they want to make sure that if they lose on it, the record's clear on it. Now, there are ways to do it and ways not to do it. You know, sometimes people get frustrated and they say, well, this is reversible error, so let me tell you why. Well, don't do that. But to say, Your Honor, I think this is an important issue. Can we just take a few moments and talk it through? I was always receptive to doing that. I found it was really helpful. Now, again, there is a point of excess you can get to where if every 10 minutes you're asking to have the jury taken out of the courtroom so you can discuss an issue, I'm going to start getting frustrated about that because we're wasting the jurors' time. And so I would suggest as well that if you think you have something complicated coming up in a trial, if lawyers would give me a heads up, I'd say, well, tell you what, let's take a half hour, an hour after we finish with the jury today, and let's talk it through. So from a trial judge's standpoint, you never really want to be surprised. Now, I know trials can't be scripted and things happen that nobody anticipates, and I get that. But to the extent that you can anticipate major issues and either raise them before trial in a motion in limine or at the end of the day or whatever the case may be, that really does make the judges feel much better about it. I don't mind sitting out on the bench listening. I just mind sitting out on the bench listening when I have 7 or 12 or 14 people back in the jury room.
Yeah, that's always been my experience. Not doing trial work myself, but sometimes second chairing a trial.
Yep.
Sometimes
Right.
reading trial transcripts, how protective judges are of the jury's time. If you really want to get a judge angry, do
Yep.
something to make the jury sit out in the jury room
Yep.
while you bring an issue to the court's attention. Most jurors don't want to be there. You know, the kind of conventional wisdom of, I got jury duty, got my notice, I'm not happy about it. Oh, it seems to me most jurors kind of appreciate the experience after having gone through it. But
That's exactly right. That's
Yeah.
exactly right. Nobody wants to get that summons, but once they finish the experience, they find it really valuable.
Yeah, it wasn't so bad after all, I guess. So that was interesting because maybe it's because I do brief writing, but I always try, if there's any issue I can think of that it's going to come up, evidentiary issue, even a jury instruction issue, is to file an limine motion. Because if you want to have something preserved, it's in writing, it's filed. It doesn't matter if the judge doesn't give any time, issues a precipice order or decides that oral argument, you're on file with your writing. So what maybe some tips on what happens if an issue that's completely takes everybody by surprise and you're unhappy with the evidentiary issue, or maybe the testimony is surprising, someone refers to insurance, for example, or something like that, about how to preserve the record when you don't get the benefit of an eliminating hearing, and maybe it's a sidebar or something like that, about maybe what the attorney should do when he or she finds themselves in such a difficult situation.
If something goes terribly wrong, and this only happened a few times in my 14 years as a trial judge, I would send the jury home for the day, apologize that we were finishing early, and then just take all the time it needs to try to get it straightened around. Particularly when you're deep into a trial, nobody wants a mistrial. And it's in everybody's best interest to see if you can clean up the mess, no matter how messy it is. And sometimes it takes time to do that. But in terms of just making a record when things are going along in the flow of the trial, you really need to know, for example, whether you have a judge who's recording sidebars or a judge who's not recording sidebars. And by recording, I mean either having an old-fashioned court reporter there or recording. You know, more and more the trial courts are going to the recording systems. And I had my courtroom set up in such a way that we could record sidebars. And so you knew that you were making a record, but that's not the case everywhere. And you really need to know that, because sometimes you'll press your point, you'll say everything you want to say, and then you won't find out until you get the trial transcript that none of that was recorded. And so there's no record of what happened. And so there's nothing wrong. We would invite lawyers in on the Friday afternoon before a trial started on Monday to just get the lay of the land, try out their electronic equipment. We'd have everybody on staff available. And so you could ask one of my court recorders, hey, are sidebars being recorded or not? Now, I would always try to make a point of letting people know we are recording sidebars. So when we're talking at sidebar, you're making a permanent record. But you really need to know that before the trial starts, because it affects the way you behave. You have to make a record, as you said at the beginning, Tim. Sitting in the Court of Appeals now, I can tell you that it is an enormous hurdle to getting relief on appeal if there's no record from below.
Thank you. And Samantha, I see a couple of questions have popped up. Are either of them good time to ask these questions? Are they more appropriate maybe later on?
I think we can hit some of them now. They relate to motions for summary disposition. So I think
Sure.
Good. The first one is more of a situational question. It says, I had a situation where the trial judge granted summary disposition, quote, for the reasons stated in defendant's briefs, end quote. One of the reasons stated, but not the only one, was based on a case that has since been overturned. Subsequently, plaintiff filed an appeal based on overturning of the case cited by defendant. What is the best approach for getting the Court of Appeals to affirm the grant of summary disposition based on the other secondary arguments presented to the trial court?
Well, I think the best thing you can do in that circumstance is admit straight up that a case on which you relied and prevailed has been overruled, and then explain, but we still win for the following reasons. What I wouldn't want to see is no issue related to the particular case. And so I have to dig it out and figure out that you won for a different reason below. And now you're trying to bury that reason and give me some other reasons that the trial court didn't rely on. I mean, it happens. And so we on the Court of Appeals are never going to hold it against you if you cite, for example, one of our published opinions and the trial judge relies on our published opinion, which of course is binding precedent. And then 8 months down the road, the Michigan Supreme Court reverses. It happens. And so the best way to handle that when you're writing your appellate brief, you'll be appellate, presumably because you won below, is to indicate both in the introductory paragraph or introductory page. By the way, I love those in briefs. They're incredibly helpful. That the trial court ruled in your favor based on a Court of Appeals decision that has since been reversed, but we win for the following reasons anyway.
And then Sam, how about the other question? Looks like it's about oral argument, but I don't see any reason. We don't have that on the outline today. So this, I think, would be an appropriate time to ask that question as well.
Okay,
Sure.
perfect. All right. The question is it inappropriate for the Court of Appeals to allow oral argument by an appellant who did not properly preserve oral argument? I preserve my right to oral argument and plan to object if appellant seeks to also give oral argument. Is such an objection frowned upon? Will it make me look bad if I object? What outcome should I expect?
This is a problem. And we've wrestled with it on panels quite a bit already. I've only been here a year, but I've seen this come up quite a bit. Sometimes people don't realize that they have to ask for oral argument. And then other times people just simply blow past the time limit and they lose it. Typically, what we'll do is we'll allow anyone to stand for questions. But if you stand for questions, that's all you're there to do. And I think a lot of experienced appellate practitioners know that. And so now they're filing motions requesting time for oral argument. You can oppose those if you like, but if you're endorsed for oral argument, and even though you've done everything right to preserve the right, if you're coming in to make an argument, particularly if you're appellate, we're probably just for our own edification going to allow the appellant to come in and make an argument too. I think your argument's a little stronger if you don't plan to present an oral argument yourself as long as the appellant doesn't get to present one. But please understand that it just seems not so much fundamentally unfair, but fundamentally confusing for us to hear only from the appellee when the appellant wants to say something out loud. Now, having said that, I suspect you all probably know that in most cases in the Court of Appeals, we've come to some sort of rough conclusion about how the case should come out before we even hear oral argument. Has oral argument changed my mind? Yes. I mean, several times. I can count 3 instances where I went to oral argument where I had written the proposed opinion. And after oral argument in conference, I told my colleagues, now that I think about it, this probably should come out the other way. I knew it was a close case going in, but so I went back and rewrote the opinion and changed the result. So oral argument isn't as essential as writing a good brief, but to the extent that it makes a difference and both sides want to be heard, I'm sorry to say that we're probably going to allow both sides to be heard.
Thank you for saying that. That's usually it comes from the client. You filed your brief on time, the other side didn't, and they want to get their argument. And I tried to explain to them, we only look weak and we look like we've got something to hide if we're trying to get in the way of the court that might have questions of the other side. So it does more harm than good to oppose it, even though, they skirted by the rules. So that's interesting to hear you.
Right. Yeah. I mean, we're more practical than rule bound when it comes to that.
Okay. Looks like that resolves those 2 questions. So now we can maybe move into more trial questions. And
sure.
From my perspective, when you've got a jury verdict that you want to appeal, and I get brought in to contest a jury verdict or defend a jury verdict, the first thing I always ask for is the verdict form and the jury instructions. And I know that there are certain issues, for example, if they're not preserved in the jury verdict form, you're completely out of luck. And for me, if it's a big damages award, the biggest one is not having the future damages segregated out line by line, year by year. If it's just a lump sum of future damages, you don't get the reduction of present cash value. That's getting the weeds a little bit, but that can sometimes be a 50% or more discount on the actual judgment amount once those future damages are brought into present value. So those kinds of fights and arguments over the verdict form and the jury instruction, in the good old days before Zoom, everything was not everything, but it's typically done in chambers. Which is definitionally off the record. So again, maybe Judge Yates, if you can offer experience from trial court and Court of Appeals on how best to, again, not irritate the judge by saying we must go on the record to do this, but at the same time, preserving challenges to jury instruction, the verdict form, things that maybe didn't get your way on back in chambers, and maybe how an attorney could best approach that issue.
Well, first of all, I think it's terrible practice for any trial court judge to simply hold an off-the-record conference, whether in the courtroom or in chambers on jury instructions, and then not have an on-the-record session where the court invites both sides to make whatever objections they'd like to make and preserve. As a Court of Appeals judge, that drives me crazy because I don't know what happened in chambers, and I can only guess. And so if there's a fouled-up jury instruction, or if there's a standard instruction that wasn't given that should have been given, I have no reason to know why that instruction wasn't given or where some screwed up instruction came from. And so it's darn near impossible to conduct valuable appellate review. We'll do the best we can, but that just doesn't help. So if the judge wraps up the in-chambers conference by saying, okay, so we're set to go, I, as a trial attorney, would say, may we briefly go on the record and discuss the jury instructions either now or before they're given, just simply so I can make a record of what I didn't get that I wanted. You may get some pushback from a judge on that, but you shouldn't. And if you do, you should persist because you have to be able to make a record about jury instructions. And the biggest problem with jury instructions is if you don't object on the record, it's presumed that you just assented to everything, and then you're really in trouble on appeal. With regard to verdict forms, This is an age-old problem. I always tried to write my verdict forms in such a way that we could tease out what the jury was thinking on almost every issue that could be of consequence on appeal. And so, unlike a criminal verdict form, which is usually only a page or two, some of my civil verdict forms would run 25 questions and span 10 pages. And I'd always have to spend some time making sure that, if you answered yes, go to question 2. If you answered no, go to question 3, and so on. You have to make sure that the numbering's all consistent. But I always appreciated, particularly in complex cases, when attorneys brought in proposed verdict forms early on. And so I had days and days to look at them, think about them, revise them, and try to make them work. If you're going to try to bring in some complicated verdict form, you can't expect to drop it on the judge right when the jury instruction conference starts and get a logical ruling on it by the end of the jury instruction conference. So the best thing I can tell you about that is I always appreciated getting proposed jury instructions well in advance of trial. And the dumb thing about having to do all that work on your side is 90 to 95% of the jury instructions are totally unremarkable. They won't be a basis for any fighting. And yet, you'll have 2 or 3 that really matter a great deal. So highlight those instructions. There's nothing wrong, for example, with listing, I'd like the following standard instructions, just list them by number, and then attach any special jury instructions you're going to use, the non-standard ones, and attach any sort of complicated verdict form you want to use. That to me highlights where the problems are likely to be.
That's again, good information from the trial perspective and appellate perspective. I don't see any more questions for the time being. So I thought maybe I had a couple of remarks that kind of bookend with where we started about the purpose of issue preservation, and see if there's any question and maybe any follow-up from Judge Yates. But again, starting with the idea that the Court of Appeals wants to see that the appellant, took every measure possible to try to prevent the Court of Appeals from having to fix an error. So again, in my experience, if a witness slips and says something the witness should not have, don't just sit idly by and let it go. Request a curative instruction. If you don't request a curative instruction, you're going to find an opinion that says, well, if you didn't like that testimony, you should ask the judge to issue a curative instruction. Jurors are presumed to follow their instructions. Again, one more self-help measure a party can take. And again, this is experiential. It's not in the court rules, but you can raise a sufficiency of the evidence challenge for the first time on post-trial motion. Now, technically, that issue is preserved if you, wait till after 3 years of pre-trial, 2-week trial, jury instructions, jury deliberations, verdict, then file a motion for J&OB or something like that after trial for the first time. Technically, you can, but I've actually heard trial judges say as much in chambers. And I have to imagine there's kind of a instinctual feeling in the appellate bench as well, that if you had some dispositive legal issue and you didn't raise it until after everybody spent so much time and energy and the jury spent so much time and energy, you raise it for the first time, why'd you not file a summary disposition motion or even a directed verdict motion? Although technically you could have waited until post-trial motion. That's maybe not the best practice. Again, so get your dispositive legal issues up front, raise them early. Don't wait till it's well too late. Because the trial judge is going to say, you forced me to sit through this trial when you could have raised this a year ago and we wouldn't even be here. It's just kind of a natural reaction that you're going to get, just a resistance to affording you post-trial relief. And I have to imagine appellate relief as well.
Yeah, that's a good point. One of the difficulties, if you don't move for a directed verdict and then come back in a post-trial motion and ask for relief, is you're essentially having to convince the court that no rational juror could have reached that verdict. And yet 7 perfectly rational jurors in the judge's mind just reached that verdict. So the argument seems to ring a little hollow. It's one thing when you present it in a motion for summary disposition or directed verdict, where we're just trying to think of what abstract jurors might do. I mean, I have no idea what verdict the jury is going to return, and I may be leaning your way. I may be thinking, boy, there's really nothing to the plaintiff's case here, and I wish they'd move for a directed verdict so we could just shut this thing down and be finished with it. But if you don't move for a directed verdict and then the jury returns a verdict against you, it's pretty hard to convince the court that, well, under essentially the same standard as the directed verdict standard, you should win because no rational juror could reach that conclusion.
See, does not look like we have any questions. We don't have any more any more material we intended to cover, unless there are any final questions or final comments from Judge Yates or anyone else.
Yeah, let me just offer a couple of comments, Tim, on some areas that I think practitioners find nettlesome. The first one is you'll see a lot of our opinions that have imported the plain error standard from criminal cases, and we used it in child protective proceedings, and now you're starting to see it crop up in civil cases as well. There's a healthy debate going on in the court about whether in civil cases the rules should be strictly raise or waive, or alternatively, whether there's essentially a civil analog to the criminal plain error review, where even if nobody said a word about it in the trial court, if the error is plain or obvious and affected substantial rights, we should grant relief. So far, I'm willing to entertain plain error arguments, although in a civil case, I've never once found plain error. So I don't know whether that means that it's a hopeless endeavor or that I like being able to have plain error so I can settle issues by writing that, well, it was the correct result anyway. But I know that everybody's struggling with how we're going to react to that argument. And I don't mean to say that we have a uniform position or even a definitive position among the various judges on the court, but that's something that I'd like to highlight. The second thing I would say about dealing with our court is that we seem to, lots of people, just to be this black box. You send things up here and you get what seem like cryptic Delphic rulings from us. I want to say this about motions. Anytime somebody files an application for leave to appeal on an interlocutory basis, the most likely result you'll get from us will be a 1 or 2 sentence order, motion for immediate consideration granted, application for leave to appeal denied because we do not believe that this issue needs to be considered at this point, or whatever the magic language is. But please understand what comes behind that is usually a comprehensive memo from the commissioner's office here. There'll often be a lot of communication among the 3 judges on the panel by email or sometimes in person, because we still do them on a district by district basis. And so when you move for reconsideration of a ruling on a motion, I don't want anybody to be misled into thinking that, oh, we didn't really look at it very carefully. But now that you point this out, well, now we see that we were wrong. In all likelihood, that 1 or 2 sentence order reflects an enormous amount of thought and consideration by 3 separate judges. And I've started to try to put a sentence or 2 into some of the orders that I think are slightly more controversial or more susceptible to review by the Supreme Court, just to let everybody know, hey, we thought about this, and this is why the lead argument won't work. I don't know whether you would find that helpful if we did that a little bit more often, as opposed to just simply issuing this 1 sentence pronouncement that we're not going to grant the motion, or we're not going to grant the application for leave to appeal, or whatever the case may be. But just thought it would be helpful to know that.
Yeah, that does raise a good issue. This is getting really into the appellate weeds. Sometimes interlocutory order on an application will say it's denied for failure to persuade of the need for immediate appellate review or something like that. Which basically saying you might
very
have something here, but wait until the end. But the death knell is when you get an order from the Court of Appeals that says your application is denied for lack of merit in the grounds presented, which is then the law of the case, which is extremely frustrating to have 1 sentence decide an appeal. So the fact that maybe the court in Grand Rapids is offering a little more rationale for its rulings, I think would be helpful, as opposed to having 1 sentence as law of the case. And maybe there would be some explanation of how the court came to the conclusion.
I can see why that would be tremendously frustrating, because a lot of times we simply don't think it's the right time to take on the issue. I would prefer to use that language about, for lack of merit, the grounds presented, only in circumstances where all three of the judges on the motion panel think this is just a dead loser, because that shuts down further discussion of the issue, at least I hope in a practical sense. But I don't want to send that signal if what we're really saying is, it looks kind of close, but we just as soon have the trial court wrestle with this case for a little while longer, and we'll see it back around when, if there's an adverse verdict, we get the opportunity to take a look at the motion for summary disposition. The only other thing I wanted to say, Tim, because I know that you and I had highlighted this in some of the discussions we had back and forth. There's an interesting question about the relationship between trial counsel and appellate counsel, and I'd like to talk about that a little bit. I'm really active on Twitter, appellate Twitter, law Twitter, all of that, because I find the discussions really helpful. I mean, I'm in regular communication with justices on Supreme Courts in other states and the Court of Appeals judges in other states. And Rafi Melkonian, who's the dean of appellate Twitter, has advocated regularly and very persuasively about looping appellate lawyers into the trial court proceedings. I'm not talking about paying somebody to sit through the whole trial so that you add another layer of cost on, but just running things by the appellate side of your office. When I was in the U.S. Attorney's Office, I was there for 7 years. I was assigned to the appellate division. I did a lot of trial court work, but I was always available anytime anybody was jammed up in a trial and had a sticky evidentiary issue. And I drop everything and even run to the courtroom if I had to talk something over with the assistant U.S. attorney who was running the trial. And it's amazing how helpful appellate specialists can be, even on the fly, but especially when you give them a heads up, if you're the trial counsel in a case. And I just strongly encourage those of you who are trial counsel to consult whenever you can, if you have concerns about your case, with somebody who understands the appellate process better than you do. I'm not saying you don't understand how the appellate process works, but we now have more and more appellate specialists, and it's a real boon to the profession. I think the quality of the work in the Court of Appeals seems to improve every single year because more and more people are specializing. I mean, once upon a time, anybody who'd try a case would think, I don't like the way this came out, and darn it, I'm bringing an appeal. Well, do you even know where the Court of Appeals physically is?
And vice versa, again, not doing any trial work at all. Always make sure with the trial attorneys I'm working with, just say, hey, I'm going to take this position. I want to make sure it's not going to jam you.
Yep.
With the judge.
Exactly.
You're going to take some inconsistent position. And I think the collaboration goes a long way if you've got a good relationship with the trial attorney to go back and forth for that very reason. Yep.
No doubt about it. I mean, that sort of dialogue strengthens the trial presentation and it strengthens the appellate presentation. There's nothing but good to be had from that.
I agree 100%. Well, not sure. Oh, there's Nathan. Well,
Oh, there we go. Well, thank you, Judge Yates. Thank you, Tim, and thank you, Samantha. Looks like we don't have any other questions at this point. Thank you very much. I mean, this is great for me as well. I especially enjoy the discussion of interlocutory orders toward the end. And I completely agree that when you get a lack of merits order with no explanation whatsoever, it is one of the most frustrating things in the world. So I appreciate that insight. There will be a survey sent out, and for all the attendees, if you can fill that out and let us know what you thought of the event, that would be much appreciated.
Thanks, everyone. I really appreciate it. Great.
Thanks, Judge Yates. Thanks, Nathan. Thanks, Samantha. Thanks, Matt.